Good morning. Please be seated. We're here for oral argument on Williams versus ADES Lamont. It's our number CV-25-0157. A couple things before we get, one thing really before we get started, which is that each side has 20 minutes. You may keep whatever time you'd like for rebuttal, but you have to keep your time yourself. Please proceed.
Good morning. Hi, challenge. Madam Chief Justice, and may it please the court. Lucy Davis on behalf of the Arizona Department of Economic Security. I'm going to aim to reserve at least 5 minutes for rebuttal, and I will watch the clock. Since 1981, ARS 41-1993B has required the Court of Appeals to give DES an opportunity to appear in judicial appeals of judicial review of appeals board decisions, which of course includes UI claims. So for more than 45 years, DES has routinely appeared in UI appeals pursuant to that unambiguous statutory authorization, and the legislature has never said otherwise. That undisturbed practice and understanding is telling and good evidence that there is only one reasonable plain meaning of the statutory text, that DES, like other parties before the appeals board, is entitled to appear and be heard on all disputed issues. Now, Miss Williams, and the Court of Appeals have deviated from that plain text based primarily on three false premises. The first false premise is that UI appeals are purely private disputes between employers and employees. That's just plain wrong. UI benefits are paid with public monies, funded by state tax dollars, for which DES is accountable under state and federal law. Indeed, DES has its own tax enforcement unit dedicated to collecting UI taxes. And unemployment insurance is just that, a public insurance program. There are no separate piggy banks of private employer dollars, and employers don't get their tax contributions back just because they may never have an employee collect UI. The second false premise is that standing has any role to play here at all. As this court's cases make clear in countless federal cases, standing applies to litigants seeking relief, litigants seeking redress from the courts. It doesn't really have any application to appellees that are already in a case, merely arguing in favor of affirmance.
Is there a distinction between standing and a statutory right to appear?
I think in certain contexts, perhaps, but it doesn't, that kind of capacity of authority to appear standing distinction doesn't make much sense here for a few reasons. So, when you think about capacity in the context of a governmental entity, it's normally, is it a jural entity, right? Is there statutory authorization to sue or be sued? And that would be a really strange way to think about this statute when DES is an appellee, neither suing or being sued. But I guess I'm not going to hang my hat or die on the hill of we can't call this standing, because even if you think about it that way, and I don't think that's right and like to get to that, but even if you think about it that way, you have this clear authority to appear language, and then the myriad interests that we've explained that give DES a judiciable stake in these appeals.
Counsel, let me ask you a question about it, because I don't think if the statute says what you say it says, and we read it the way that it's written, why be afraid of saying that it gives you standing? I mean, we've previously addressed the declaratory judgment statute as conferring statutory standing on litigants. And I wouldn't be so quick to give up ADES's role as a litigant here either, because within 1993B, it references the ability to receive taxable costs if the department prevails. Only a litigant can prevail, right?
It's Justice Montgomery, I certainly agree that if you think about this as standing, then 1993B confers standing, and the legislature clearly can do that under this court's cases. So I don't think standing is the right framework because of the posture. And I think, if the court is going to go down that road, it would be helpful to lower courts, I think, to at least clarify that standing isn't an argument by argument analysis for all parties on both sides of the V. There's really no precedent for thinking about it that way, and I think that would cause significant confusion. And the cases that, and again, not going to quarrel.
What's the authority you're relying on to suggest that that would cause confusion? Because under the statute, if ADES can appear, okay, they're going to be on the other side of that V. I don't understand the point you're trying to make that might cause confusion. If we tell lower courts, we tell future litigants, the statute says what it says. ADES may appear, they're a litigant, they have been conferred standing by the statute, by the legislature. Because if you start getting into justiciable interest, now you're taking us down that interest road, which I don't think you really want to.
I'm not afraid of going down that road, but I'm certainly perfectly fine with the first part of what you said, Your Honor. And if you want to write the opinion like that, that's fine.
I don't get to assign it.
Well, of course not. But I mean, in terms of standing, I just want to make one quick point about this. So the cases that the Court of Appeals cites on this, Miller, Kerr, Goobser, Goglia, when you actually read those cases, they're about litigants that have asserted the injury or interests of non-parties, right? And that makes perfect sense with standing principles. We generally require litigants to raise their own interests. Or even in Evertson, there was really no dispute when you go back and read it that the Industrial Commission was purporting to raise the interests of others. I mean, that opinion literally uses the parens patriae framing. And so this is just quite different. DES has never been purporting to assert the interests of others. It's only asserting its own interests. And I guess the confusion, I agree there wouldn't be any confusion as to DES. The confusion I'm referring to, I think, would be in other contexts where courts might think they now have to analyze every single argument raised by, defendants and appellees in all cases for standing. And that's just really not the way standing cases have ever looked at that issue.
I'm going to switch subjects. So
Well, just one quick follow-up then on that, because aren't we then talking about the different types of exclusion? In which case, when we're saying that the legislature has conferred standing on ADES, it's standing in particular circumstances. And you referred to some of the other cases that dealt with other types of exclusions than necessarily what we might have here. So isn't that what we would just be focusing on?
I'm not totally sure I'm understanding your question.
So I think if we go down to, if we're looking at bases on which ADES is appearing, and you've got the other cases that you mentioned will refer to whether or not, was this a private party dispute? Is this a determination of eligibility benefits, or is it the third category? If we're dealing with the other two categories, there might be more analysis required to see whether or not the ADES is appearing, whether ADES is appearing in one of those three particular categories. And the analysis might differ there. But at least for this type of case, isn't it rather cut and dried?
I agree this case should be cut and dry based on the statutory language. I think importantly, and I don't want this point to get missed in the briefs, 41-1993B is not just a procedural component of UI. It applies to all judicial reviews of all appeals board decisions. So that includes SNAP, DDD, and significant now terminated programs like TUA, PUA, and emergency rental insurance. And so I think, the legislature is well aware of the other programs it's assigned to DES to administer. It could have treated UI differently. It hasn't. And in fact, the way it treats DES in this context is analogous to how it treats DES in other contexts and other agencies. Just look at the JRAD statutes. And there are certain decisions from DES that actually go from the program to OA to the director, and then would proceed under 1993A to the Superior Court and under JRAD statutes, which I think just underscores that, you know, the legislature has excluded OA as a party in JRAD proceedings, but not the appellee agency. The legislature knows how to do this and hasn't done it here.
So, Ms. Davis, I wanted to ask you a question that neither party addressed, but is giving me some concern, and that is, in many cases, DES is going to be a nominal appellee. But where it becomes an advocate for the merits of the decision it's reached, what do we do if we have to remand the case to DES? That seems then, you know, you're not remanding it to a disinterested tribunal, it seems to me. And we do that. Rosas as a recent example, but their DES was a nominal appellee.
So a few points on this, Your Honor, and I appreciate the instinct behind the question. I guess I'd like to talk about why there's actually no inconsistency between DES's statutory and pecuniary interests in administration of the program and its ability to be impartial, and that those are actually mutually reinforcing. And then I'd also like to get to the due process concern that's sort of lingering behind your question. So on the first part, I think it's really important to remember, it sounds simple, but it's sort of a paradigm shift from the way the Court of Appeals thought about this. These are eligibility determinations for a public benefit about whether public monies could lawfully pay out. It's not a prosecutorial enforcement proceeding, and it's not a normal civil adversarial matter. I mean, Dynametrics says that in other cases too. So when DES's interest is not in granting as many benefits as possible or in denying as many as possible, its interest is in getting it right. It's required by federal law to make sure that it's accurately determining eligibility. So there's nothing inconsistent about that interest in just getting it right, whether that means for the employer or against the employer. It's not really like that. It's about whether eligibility is appropriate or not.
That does sound, though, and I had the same concern that Justice Bullock, we're often on the same page on these things.
I've not had that
It
experience.
strikes me what you're saying, though, is trust us that DES will keep these things separate. But here, for example, DES is making some arguments that I don't think that the board even did, saying, well, you know, she didn't, you know, do something after termination, giving back a password, that kind of thing, which couldn't have formed the basis. So it seems like they're invested. So how is she or anyone in the public to have faith that you're going to get a fair shot if there was a remand?
Sure.
Going back.
So, and this is the part of the question. There's no legacy fund Hornby Polk problem here at all, because if you look at deputy determination, ALJ, appeals board, case evaluation by general counsel with AGO counsel, and then going to a UI appeal if it proceeds, at no point in that sequence is a single individual or a set group of individuals wearing all the hats, making all of the decisions. Deputy is in one part of the department, appeals board, ALJ are in a separate administration in a different part of the department. And if there is a remand required from a UI appeal, it's going back to people in the agency who had no role in shaping the position of the department in a UI appeal and determining what position to take. So there's no overlap. And I think even Legacy Fund says that, well, Hornby Polk says no problem with multiple functions in a single agency. And Legacy Fund even says there's no even problem necessarily with proximity of the functions, right? Because there the court said that the staff could have been the ones to have made a advisory kind of prosecutorial decision, and then the commission could have been the decision maker. And here the decisions are even more spread out.
The distinction, though, on a remand is that the agency has weighed in as an entity. It's sort of like the end of the process has already, the normal process has already occurred. And that does, you know, it certainly doesn't seem dispositive of the issue before us, and it may be a prudential consideration on the part of agencies, you know, like if we become an advocate, we may back ourselves into due process considerations if the case is remanded. And I don't know where else you would send one of these, one of these cases if a court were to conclude that the agency had, had basically done what the Chief Justice indicated.
Well, I certainly agree it's not dispositive here, and I guess I just would push back against the instinct that there is a problem here under this court's cases. And again, I just come back to it is really important that this is an eligibility determination. And let me try another way of trying to both concretize the interests and why they continue to the UI appeal stage and why that's sort of harmonious with how we think about these things. There's a state law reason and a federal law reason. So I think under decades of precedent of substantial evidence review, in this specific context, which this court reiterated just recently in Barriga, paragraph 19, there's nothing improper or strange about DES raising additional reasons that the appeals board might not have expressly passed on to say there's other reason in the record that supports this determination. So I think that's well established, and those cases sometimes involve a remand, and there's never been any due process challenge raised. But there is
just to be clear, so I know your time is going, that there is no constitutional challenge to this statute here today, correct? So we're just looking at what does the statute, well, not just looking, but does the statute, among other things, does the statute authorize DES to appear and argue?
Correct. I do have a federal law point, but I am going to reserve the remainder of my time, if I may, and I'll pop back up in a little bit. Thank you very much.
Thank you.
May it please the court. My name is Ashley Mahoney. I represent the respondent, Gayla Williams. This case is not about whether the Department of Economic Security can ever show up in an unemployment appeal. It's about whether the department may appear solely to vindicate the position of an employer who decided not to appear itself. This court should affirm the holding that the department lacks standing because it has no cognizable interest in whether a particular claimant receives unemployment benefits. Should also affirm the award of attorney's fees because 12348H1 is inapplicable when a neutral adjudicator turns into an adversary. Requiring a party to have an interest in the issue being decided is not new, and in this case, the department's interest has to be considered under the Employment Security Act. The purpose of the act is to ease the financial burden of unemployment on claimants and to hold the employers accountable when they contribute to unemployment. Here, the department decided a dispute between an employer and employee. Then on appeal, instead of staying in its neutral role, it stepped in and argued the absent employer side of a purely factual case. It argued that Ms. Williams engaged in a pattern of insubordination, uses the employer's unsupported allegations that were not found by the board, or used as the board's basis for its decision. This is not neutral participation, it's advocacy for one side, and it has destroyed the department's credibility as an impartial tribunal. Section 41-1993B gives the department notice and an opportunity to appear. That gives it a seat in the case, but it doesn't automatically give it standing to argue any issue at once. If being allowed to appear were enough, there would never be a standing analysis. Arizona law treats those as different things. Capacity is just the legal ability to be in court, but standing is different. Standing means you have an actual interest in the issue that you're asking the court to decide.
Well, is there anything reading 1993B, it first says that you had to be an aggrieved party to even file an application for an appeal. So DES certainly isn't allowed to do that. But then once it's granted, it seems that the department and all parties shall be given notice and an opportunity to appear. I don't see that they're treated any differently than an aggrieved party, at least from the text of this statute. And then indeed, has been pointed out, it does go on to say in terms of costs that it recognizes that the department can prevail, which certainly seems to indicate that they can take an advocacy role just like a party. So although I understand the concerns with having DES be assuming that role, and you've certainly pointed them out as the Court of Appeals. How do we reconcile that with the actual text of the statute?
So I'll take those in reverse order. In this case, to prevail means to maintain the status quo. It does not equate to advocacy. And additionally, the unemployment appeals proceed under the civil rules of appellate procedure, which has a cost recovery provision. And so the statute is simply saying, in this context, this is what a taxable cost is. Doesn't equate to advocacy.
Well, let me ask you about when you said prevail, it maintains the status quo. Does it? I mean, I wonder, it seems odd, but could the department take the side of someone that did not prevail before the board? So it had a reason thinking, boy, this was far off. So this board was off. So we're going to actually come in and take the side of the party that did not prevail. Does anything prevent that?
I think it would be improper for the department to take either party's side. If it's the case of taking the same position that one party has taken, I think in certain situations, if it's to interpret a regulation, the department could have a legitimate interest. But this is a purely factual dispute. The employer had the burden of proving misconduct in this case, and the department has no interest in whether the employer met its burden.
Well, this idea of having an interest or no interest, that's certainly a limitation on what the statute says in terms of notice and an opportunity to appear. And I guess what I'm searching for, at least, is where is the limitation that you're asking for reflected? How do we tie that into the statute? Where is the language that supports that reading of the statute?
So I think an interest in the issue being decided is inherent in the system. It's not discussed in most cases at all. Something that I was thinking about as a similar situation is a party in a case that is there because it has an interest in the outcome of the case may not be able to object to a third-party subpoena because it's unduly burdensome if the third party doesn't object to the subpoena. So the party's there, but it doesn't mean that it has an interest in the actual issue being decided. The statute does say that it has the opportunity to appear. It doesn't say, however, that it has the opportunity to appropriate the employer's position and basically adjudicate as if it were the adversarial party.
Counselor,
What about the argument that's been raised with respect to, though, the interest in that DES is really the guardian of these taxpayer dollars, and their role is to ensure program integrity, among other things. So does that give DES some sort of role here that differs, for example, in the context of workers' compensation and other programs that may be administered within the state?
It does. That DES does have an interest in eligibility, and I think that is distinguishable from an interest in whether the employer proved that the employee was terminated for a disqualifying reason. So under Section 23-775, the department does have an obligation to make reasonable efforts to determine eligibility, but eligibility is basically the baseline floor of, did you apply, were you timely, do you qualify to even enter into the unemployment system? Now, if an employer comes along and says that there was misconduct involved, that is solely the employer's burden. In fact, if the department did have an interest in determining misconduct, then the deputy would have had to make an independent investigation into misconduct before ever awarding benefits. And in this case, Ms. Williams was awarded benefits before the employer decided to appear and then to say that there was misconduct involved. So they can't have the same interest now that they had then if they didn't have any interest in proving misconduct at that point.
Are employers routinely incentivized to appear, pay a lawyer, and defend their position in each unemployment eligibility claim?
They're incentivized by the system that's been created by the legislature. That's the only system that we have. They're certainly not more incentivized when the Attorney General shows up to defend their position. If it's not enough, then that's a legislative issue.
well, Counsel, why isn't it a legislative issue then? Because I think you make a very reasonable argument about how DES might need to be limited in their particular role. Great policy, but why isn't that a legislative issue? Because it seems you're asking us to make a distinction in the text between a party and DES when both within that same sentence are given the same right to notice and to appear?
I think that this court has brought it up today. What happens if this case gets remanded? Which this case was remanded to determine the amount of benefits. And so does Ms. Williams think that she's going to have a fair shot in front of the board the second time around?
Well, that may be a bridge we haven't crossed yet. It's a fair question. We've been talking about it. And should that circumstance come up, that might be something else for us to worry about or highlight for the legislature in a footnote. But I think you make a good argument, too, with respect to what DES did in this particular case in advocating on behalf of the employer. And I'm wondering why the third to last sentence of 1993B doesn't address your concerns in that the appeals are supposed to be limited to the record before the department, and the issue can't be raised on appeal that wasn't issued or raised in the petition for review before the appeals board. So if we were to remand this to the Court of Appeals to make its determination on the merits of DES's position, I think there's a great argument that that review has to be limited and that DES can't basically expand the record and make arguments that weren't already presented. Would that address your concerns about, certainly not with respect to taking an advocacy role to begin with, but with respect to DES sort of doing employer plus?
Well, in this case, the Court of Appeals did reach a decision on the merits, and it did use the board's written decision, which is the record that is in front of it.
But I guess to be clear, but they wouldn't take up what DES's positions were because they found that DES didn't have any standing. They did review whether Williams was entitled to eligibility. But I mean, if we were to remand on this and they were to consider DES's arguments, highlighting this particular portion of the statute would limit what those arguments could be. Would you agree with that? So I can end with a question.
I think the decision would be the same because the record is the written decision and anything that was provided to the tribunal or to the board. And so coming in and bringing up allegations that weren't found, the Court of Appeals defers to the tribunal and the board's findings. Right. So can't show up and now say, well, the department wants to supplement what the board's findings were. Under the statutory scheme, the board has every tool available to it to get the decision right before it leaves the department. It can affirm, modify, remand to a different tribunal that it wants to remand to. It can hear evidence, it can do whatever it wants. And so when that decision leaves the door, that's it, it's done. This entire system was built to not function with attorneys. So below, when you're in the administrative hearing, there's a $750 cap on attorney's fees. We're looking at the purpose of the act. It would be because employers are going to be the ones that are showing up with attorneys and not employees. So the system doesn't build the entire record with no attorneys and then make an unemployed litigant show up against the attorney general. That's just not consistent with the legislative intent.
What do we make of the fact that apparently DES has been showing up and advocating for it for years, and there's been certainly amendments to the statutes, but they haven't addressed that. They haven't made the same change as they did against the Industrial Commission decades ago.
Right, and so this court hasn't decided yet whether DES is allowed to show up and make any argument on behalf of any party. So silence is not acquiescence. There has been nothing to acquiesce to.
So if DES has an interest in maintaining statewide consistency in an employment law, and what does the rule look like? What is it the rule that you want us to issue? Because certainly it can't be a determination based on sort of the fervor of DES's advocacy in a particular case. So what is the line of demarcation?
So I think in this case, the Court of Appeals decision is not as broad as I think it's being painted. It's very narrow. It's that an employer can't, or the board cannot appear in the shoes of an absent employer to take that position. I'm thinking back to the first part of your question.
So if DES has an interest in maintaining statewide
Consistency.
What does the rule look like?
I've been trying to figure out what it looks like to have an interest in consistency when you have a burden of proof, right? I don't know how DES can ever ensure that there's consistency with the employer proving its case other than showing up and proving its case for it. And that's what's happening here. So if the issue of consistency is whenever an employer accuses misconduct, we're going to show up and make sure that that misconduct stands. Otherwise, the only consistency that's happening is our decision is right. And there is no interest in having your decision be right. I think that any judge also has an interest in getting their decision right, interest in consistency of the law, but the judges can't show up and argue their point.
Counsel, let me ask you this question, though. Doesn't DES have an interest in ensuring that the eligibility determination process stays honest? And here's the hypothetical. If we were to say that DES can't appear if the employer doesn't appear, and employers just decide, you know what, we've already paid in the unemployment insurance, we don't care if employees get it. And then employees can start drawing down on the underinsured or unemployed insurance program without a real check on whether or not they truly are eligible. And it gets to the process, employer doesn't show up, and then it becomes a de facto ruling for the employee. Isn't there at least some interest there in wanting to make sure the process stays honest?
No. So eligibility is a separate inquiry, right? And so they do have an interest in determining eligibility and whether the baseline criteria was met. But if the employer is not interested to show up and the entire system starts to draw down, one, it's their system, right? So the entire unemployment compensation fund is funded by employers. So it's like saying that you have Party A and Party B in dissolution proceedings, and historically Party B decides that it doesn't want to show up on appeal. The court doesn't then show up and say, well, we're going to take up the cause of Party B. It's just that the law starts to get shaped in favor of Party A until Party B gets sick of that and shows up. And so if the employers don't like the system, then they need to show up and defend it. This is the system that the legislature put into place to give them an incentive to provide secure employment. So if that's what ends up happening, that's exactly the way it was intended to happen.
Ms. Mahoney, I'm going to move over to the attorney's fees. It seems to me, and correct me if I'm wrong, that the Court of Appeals in this case maybe didn't take into account our recent decision in Rosas, where 348H1 was applicable and precludes attorney's fees against the state where its role was to determine the eligibility or entitlement of an individual to monetary benefit. Help me with that.
So I went through the Rosas briefing after seeing it in the state's brief. And what I can say is under RCAP 21, you have to state your basis for fees. And the claimants didn't state Cortaro. So this court didn't decide whether Cortaro is an exception to that rule. So I don't think that the issue had quite been decided.
Okay, but how about this case? Does H1 have applicability? It seems like that the state is determined, they have a right to determine eligibility and whether your client had the right to monetary benefits. Doesn't it stop right there then? Regardless of what happened in the pleadings in Rosas?
It's the same provision that was interpreted in Cortaro. So it's no more inapplicable in this case than it was when the state was determining a dispute between private parties. And so that's this court's interpretation that I'm going off of. I don't think that the Court of Appeals got it wrong. I'm also trying to think of the first part of your question. Once I answered the second part, I moved on.
Well, does that set up Rosas is in conflict with, is it Cotero? Yeah, whatever. Yeah, you know what I mean. So I suppose then we've got now two conflicting cases, at least in part on that. Is there a distinction between them? Maybe the role that they were playing, whereas here you're giving, you're dealing with deciding if somebody gets monetary benefits, whereas in the other case, it was what Department of Water Resources adjudicating whether you get between parties, whether a license to pump water should be given. Is there a distinction between those cases that's a meaningful one?
So there is a distinction in showing up to defend a legitimate interest. And in Rosas, everybody was trying to interpret a statute. Cortaro doesn't make that distinction though. If you show up and you advocate, then you're going to pay fees if you're wrong. And I don't think that that's the wrong decision either. I'm glad that in Rosas, the department got its clarification, but generally does that clarification have to come at the expense of the unemployed individual?
Well, I suppose what I was kind of focusing on under the statute, H1 says, and looking at the rules that constitute the exception, One was to determine the eligibility or entitlement of an individual to a monetary benefit or its equivalent, which is here, or to adjudicate a dispute or issue between private parties, which I think was that case. And so I guess that's what I'm asking is there enough of a distinction between, well, okay, if you're in the role of an adjudicator, you can't then switch and be in this role versus this determination of eligibility or entitlement. Is that a meaningful distinction?
I think that I'm still not quite understanding the
I
question.
know. Well, it wasn't well asked, perhaps, and I think your answer is going to be no when you think it through.
It will be.
Let me get ahead of you there. That it should be the same, but that's the only distinction I see between the two cases, and so that's why I was asking.
So anytime I think that everything in each one is just referring to a decision maker capacity. So in those cases, when I'm pretty sure it's the Corporation Commission when it's talking about setting rates or adjudicating a dispute between private parties or determining eligibility benefits, those are not a situation where the state is in an adversarial position. And so in this case, if you look at it, we've come so far beyond the eligibility determination. That's not even at issue today. The state is here as an adversary of Ms. Williams. In terms of Cortaro, I think that the case is clear. I don't think that it was brought up in Rosas. It certainly wasn't analyzed in the court's decision. I don't think that the state has given a compelling reason to revisit it, and especially in the context of the facts of this case. Ms. Williams was forced to come and make arguments that had never been raised below. It definitely increased the burden in the case. That is my time. Just quickly, the Court of Appeals decision is consistent with this court's decisions in the past, and we ask that you affirm.
Thank you. Okay, Ms. Davis.
We are here about eligibility. A claimant is only eligible for UI if they're unemployed through no fault of their own, and so that necessarily encompasses the misquery. And getting to my point I was trying to make before about federal law, which is really important, I think something this court is required to consider in a federal state program. So pursuant to federal law, there is an audit team within DES that is required to follow pretty detailed methodology. And their primary job is to audit a statistical sample of UI claims that have been granted and denied. And Department of Labor, DOL, uses that audit information to estimate DES's error rate writ large. So it's really important because federal consequences can follow from not having a proper error rate. Importantly, when that audit team looks at a case, so let's say they were auditing Ms. Williams' case as part of their sample audit. They do a rigorous top to bottom review. They're not just looking at the reasons that the appeals board did. They're trying to determine at bottom, was the eligibility determination correct? And importantly, if a court of appeals reverses the determination in either direction and the audit team disagrees, under the federal methodology, it is required to mark that as an erroneous overpayment. And it's an uncollectible overpayment because the benefits were pursuant to a federal court order. So the opinion below cuts DES off from explaining to the Court of Appeals why a public benefit can lawfully pay out or not, right at the moment that it could reverse and give DES really no recourse after that point. And so I think that underscores why substantial evidence review makes sense here and why there's nothing improper about looking to additional reasons in the record. And Justice Cruz and Justice Montgomery and several others have asked questions about limitations. So there are limitations on the arguments DES can raise. They just have nothing to do with standing, and they aren't really unique to DES. They apply to the other parties as well. You can only raise arguments based on the record, based on issues that have been preserved and sufficiently developed. So look at Barriga compared to Dynametrics. In Barriga, this Court of Appeals had erred in reversing for development on an issue that hadn't been preserved. In Dynametrics, the Court of Appeals remanded for further development in the agency on an issue that was key to eligibility but not sufficiently developed. So there may be difficult and interesting questions about when arguments are appropriate, but those are going to be fact-specific, case-specific issues that future courts can deal with when they arise. I think for now, it's enough for this court to say, look, legislature has authorized this participation, and it doesn't include any of the qualifications or limitations that the Court of Appeals included.
Could you address on attorney's fees, why Cortero doesn't, why don't we follow Cortero here? What's the distinction between this case and that one?
Happily. There's no conflict whatsoever. I mean, Cortaro, remember, was a case where the court first said the monetary eligibility determination part of the clause didn't apply at all. So then the question was, does the other part apply, right? These are disjunctive exceptions. So it's not a case that stands for the proposition that you can be entitled to the exception, the state agency, based on eligibility, and then that can be undone by advocacy. These are just, I mean, even looking at H1 itself for the text that you read, Chief Justice Timmer, it sort of underscores the eligibility point I keep coming back to, because the legislature treated disputes between private parties and eligibility determinations as separate. It didn't think those things were the same. And that underscores this other point we've been talking about in terms of the nature of eligibility determinations. And I think it makes perfect sense that the legislature wanted agencies who are determining whether public monies should pay out to be able to decide how to defend that and whether to defend it without this background risk calculus of, is the court going to agree with us? And if not, are we going to be subject to attorney's fees?
But going back to the language, and maybe I'm going back to Cortero, I'm just having trouble distinguishing why the same rationale wouldn't apply. And maybe the answer is Cortero was incorrect, if that's your position. But I mean, it says this section does not apply to an action arising from a proceeding there to adjudicate a dispute or issue between private parties. That was Cortero, and it was a dispute arising from an action arising from a proceeding to adjudicate. So just because the department took the advocacy role on appeal under that language, why did it make a difference?
So let me try it this way. So their DWR was saying, if not this one, then this one. Like if we're not exempt under this, then we get this too. And they only needed to win on one, lost on both. But that doesn't mean that for DES to rely on the monetary eligibility piece, we need to win on the other one, because we disagree with the other part of the clause. We don't, in this context, in our view, these are not disputes between private parties. I think that's why the legislature distinguished between those things. There's no reason to have those two parts of the clause separately if they're the same thing. Can I eke out one more sentence to answer your question?
Finish your answer, yeah.
Well, Cortaro is different because that wasn't an eligibility case. It wasn't a determination of entitlement to a monetary benefit. So I think it doesn't apply here, and there's no conflict at all between that and ROSIS under the statutory text. Thank you very much.
Thank you. Well, thank both parties for your argument today and your briefing. We will take the matter under advisement and issue a decision in due course. Now I have to confess that I neglected to ask my colleagues if you have everything you need to stay on the bench, or do you need to go back? Everybody is nodding, so we're going to stay on the bench and give the other parties a chance to come forward. Thank you.